amazing group of people here at the Rose Law Group, and we have, gosh, 60 people joining online. So thank you again for taking the time. My name is Shruti Gurudanti. I am a partner and the director of our corporate transactions and aerospace group here at the Rose Law Group. I have been practicing for about a decade now. And I have experience doing international cross-border mergers, acquisitions, private equity investments, venture capital, lots of work in the real estate, hotel, REIT space. And off late, I have been helping a lot of startups, small businesses in expanding, growing, scaling, and finally exiting. And so I happen to understand how to be a general counsel for companies and how to help them grow, scale, and exit. So if you have any questions whatsoever on corporate, I would be the person you are welcome to reach out to. We will be talking about the Corporate Transparency Act. Very exciting, super sexy, best thing. Really not. It's kind of boring. But my hope would be to try to keep this light and informational so that you have information on what it is that you need to do, because this is a very important subject. Okay. With that, I would love to also introduce our co-host for today, Splever and Splever CPA. We have Eric Splever, who's joining us all the way from San Diego. And so Eric, take it away. Oh, you're on mute.
Other than that, I'm great. I was just going to say hi to everybody and welcome. I've looked at the attendee list and it looks like we've got tons of our clients on, and that makes us very happy because we have zero desire to be involved in complying with these requirements. And so we're super grateful to Shruti and the firm for sponsoring this presentation and educating you guys. I will turn it back to her. Have fun.
Thank you, Eric. Okay. Madeline, do you mind sharing the... Okay, so we're going to take a minute to just share the presentation. Please, I would absolutely hate for this to be a death by PowerPoint on this wonderful afternoon. So please stop me if you have any questions, comments, concerns at any point in time. I would love to respond right away. Let's not wait till the end. Okay, with that, topic for today, Corporate Transparency Act, and how this is going to affect your small business. So a little bit of background about how this all came about. So the big picture goal for the US Congress is to address money laundering. And so they came up with expanding the Anti-Money Laundering Act. And as part of that, they created the Corporate Transparency Act. It is the most notable addition to the anti-money laundering new regulations that are coming up. Interesting or fun fact, if you will, the United States is the second most secretive financial jurisdiction in the world, right after Cayman Islands. So it's not a great place to be. It's not a great rank to hold. And so we're trying to address that by bringing about the Corporate Transparency Act. So what is the purpose? What are we trying to do with this? Bad actors are concealing their identity, and they are using U.S. entities to facilitate, terrorism, tax fraud, illegal activities. So the goal is to create this mechanism where the ownership of certain entities now needs to be disclosed to the FinCEN, or the U.S. Treasury Department's Financial Crimes Enforcement Network. So keep in mind that there are severe penalties that will be implemented if you violate the Corporate Transparency Act. I will come to the penalties. Keep in mind it does include jail time as well. So they're taking this very seriously. Oh, there you go. Okay. All right, sorry about that. Okay, so general overview, what are we trying to accomplish today during this presentation? I want you all to understand who must file the reporting under the CTA, When must an entity file this? What information must you report, and what are the penalties? Okay, so who must file? The very first question. Why should you care? So the legal terminology is all reporting companies must file this beneficial ownership information report unless an exemption applies. So domestic reporting companies or foreign reporting companies. Generally, I'm not going to talk a lot about the foreign reporting companies because a foreign reporting company is someone, an entity that is registered outside the United States, so Cayman Islands and things like that, and they want to register to do business here in the US. Those entities, if they qualify as reporting companies, will need to file the information report. I will not be talking a lot about that because that is an entire discussion in and of itself. We will be focusing on domestic reporting companies. So what are domestic reporting companies? So any corporation, LLC, or entity that is created in the US by filing some sort of paperwork with the state secretary. Think of it as being a reporting company. That's the easiest way to understand it. So a general partnership or a sole proprietorship, as an example, is likely going to be exempt because if I'm a sole proprietor or I'm a general partnership, like Madeline and I started a company, we're not filing anything generally with the state. So we're exempt. However, every other entity, will likely be a reporting company. Okay, that's the basic threshold. Now, there are certain entities outside of that that are exempt from the entire CTA. Okay, so they want to try to address money laundering, but they're trying to address money laundering only with the small guys, not really with the big money launderers. Reason I say that is, if you look at this list, there are 23 different kinds of entities that are exempt that don't have to file this requirement, file the requirement. Two of these are important: large operating companies and inactive entities. And I'll get to what both of those mean. But the reason why there are certain entities that are exempt is because these types of entities already have a regulatory regime created around them. So a publicly listed company, a registered broker-dealer, an insurance company, think of any entity that already has to go through a large regulatory regime. They have to presumably disclose their beneficial ownership. And so the FinCEN does not want to sort of double dip into trying to regulate those entities, and they're exempt here. But let's talk about large operating company. So a large operating company is defined as any entity that employs more than 20 employees on a full-time basis in the United States. Let that sink in for a minute. Secondly, they have filed a US federal income tax return for the previous year showing more than 5 million in revenue or gross receipts or sales. So all the sales and revenue has to be in the United States. And the operative word is and they operate from a physical office in the United States. So if there is a big business that qualifies because it has all of these three items, think of like a pharmaceutical company or something like that, they are going to likely be exempt from the beneficial ownership reporting requirements. If you are an entity that is owned by one of these large operating companies, so if you're a subsidiary of one of these, you will likely also be exempt from the requirement. But what is interesting is, keep in mind, if you think you are falling within this exempt category right now, think if you are a large operating company today, but in the future that changes because suddenly your revenue is not hitting the 5 million, or you have less than 20 employees, you now do qualify as an entity that is required to file the beneficial ownership information report. Yes? Okay. Inactive entities. This is another very interesting one. So if you have an entity that existed prior to January 1, 2020, and I want all my real estate guys to think about this very, very actively. If you have an entity that existed prior to January 1, 2020, it is not an active business. What does active business mean? It does not hold any assets. In the last 12 months, has not seen a change in its ownership, has not received or sent funds more than $1,000. Those entities are considered inactive entities and they are exempt from the reporting requirements. My suggestion, however, would be if you have an inactive business, please close it right now. Do not keep these entities just lingering around if they have no business in them. Okay, so those are what a reporting company is. I'm going to stop there for one hot second. Any questions on whether or not your entity would qualify as a reporting company? Think about it as this way. If you have less than 20 employees and less than 5 million in revenue, you are likely going to have to file this reporting requirement. Okay?
And or just like
And less than 20 and 5 million in revenue that you've reported on your tax return and you have an office or physical location in the United States. Most businesses, a majority of American businesses are going to qualify and will have to file the CTA reporting. Okay, looks like no questions so far. Great. So when must you, we have one hand raised. Greg, I would recommend you put your question in the chat so I can address it. But if you want to keep your hand raised, I will ask you right at the end as well. Okay, so when must an entity file? Michael, please leave your question in the chat. I would love to get to it. So since we talked about the reporting company, now let's talk about when must an entity file this, right? What is the timing for it? Okay, there we go. Okay, so when to file? So the reporting regime, so all of this beautiful stuff goes into effect January 1, 2024. It's coming up, you guys, in a couple months, okay? So don't sit on this. The effective date is coming up. Now, you have to file your initial report depending on when the entity was created. So if your entity is going to be formed after January 1 of next year, then you have only 30 days to file this information report. 30 days. If you have an entity that exists today, you are an existing company, you have to file this within 1 year from January 1, 2024, or you have to file it before January 1, 2025. Now, if you are like me, you're probably thinking, well, I have a whole year, like I can get all this other stuff done and then I can think about this later. But please do not do that because I will go through the requirements that you need to satisfy. And it is a lot. So start the prep work now. Okay, so we talked about who, when. Now let's talk about what must an entity file, right? So what do you need to report to the FinCEN? So you need to report information about the reporting company itself, so the entity. So the name of your business information, we'll walk through that. The second piece is you need to talk about who the beneficial owners are of this business. And I'll talk about what constitutes as beneficial owners. And lastly is company applicants. These are folks who actually make the filing for your entity on your behalf. Okay, now this could be, and I'll walk in detail about it, but this could be the lawyers, the paralegals, the general counsel of your company, the CEO, CFO, anyone who's responsible for filing this information on behalf of the entity. Okay, so what information do they care about with regards to the entity? So we need to provide the FinCEN the full legal name of the entity. We need to provide the DBA, the current address, the jurisdiction of formation. Think about this as Delaware entity, Arizona corp, Wyoming, what have you, and federal income tax. So your EIN, excuse me. Okay, so pretty basic information about the reporting entity itself, but this is not where the issues are. This is where all of the issues start to come up. So now the CTA requires us to file information about, and again, the operative word is each and every beneficial owner and company applicant of an entity. And so what I mean by that is they're looking for individuals information. So they're going all the way up to who owns all of the entities and the intermediaries in between. So what is the information that they need? Full name, date of birth, residential address. They need your US passport identifying number, so your driver's license, something like that, and then a photo ID, basically of the same item number 4. What's interesting is that they do recognize that a lot of people are not going to want to provide this information. So think of family offices, private funds, things like that. And historically, angel investors, again, they want to hide, all their personal information. I say hide it, not in a negative way. They don't want to disclose confidential information. So there is an alternative, which is CTA has come up with this concept of a FinCEN identifier. So think of it like another social security number, EIN, or something like that. But it's a number that gets associated with the individual that you can then use going forward for all of your filings instead of having to file every time this information about each entity. We don't have all of the procedures and processes in place to get the FinCEN identifier today. The government is working on figuring out all of the details of how to get this out, but we do have that option. Okay, so here's the operative question again. Who is a beneficial owner? Now, there is still a lot of gray area on this subject, and we're not likely going to know all of the ins and outs of, all of the various nuances and details, and we'll only find that out after January 1, 2024 as the rules get implemented. But here's what they've shared with us as of today. So a beneficial owner of a reporting company is any individual, I'm going to go slow on this, is any individual who directly or indirectly exercises substantial control over the entity or owns or controls 25% or more of the ownership in the company. So I've highlighted the operative terms here: directly or indirectly, substantial control, and owns or controls 25% of the entity. And I'll go into detail on each of these. But the short version is they're looking at anyone who owns equity in the business, but they're also looking at individuals who indirectly own equity in the business or who indirectly control the business. So as a way of, by way of example, we represent here at the Rose Law Group, we represent a lot of marijuana clients. And it is very standard in this practice to have what's called a management contract, where the ownership or the ownership of the license for the dispensary is actually managed by somebody else, and they keep changing the management contract between entities in order to change the control of the license. So in this case, because of the substantial control definition, even though they don't have equity directly in the entity, they will be considered as a beneficial owner of the reporting entity. So they really, really try to stretch as far as possible in order to capture anyone and everyone who controls the business or owns the business. Okay, so substantial control, what do we mean by that? So an individual will be considered as exercising substantial control if they serve as a senior officer of the reporting company. A senior officer, think CEO, CFO, CTO, general counsel, all those folks. They have authority to appoint or remove any of these senior officers or a majority of the board. So think of it from the perspective that if someone has the authority to change the board, the management control of an entity, that is considered substantial control. Somebody who can direct, determine, or has, again, substantial influence over important decision making. So budgets, if they have control over dissolution, mergers, acquisitions, then they will be considered as having substantial control. And last but not the least, this is the best. It's a catch-all provision that anyone who has any other form of substantial control will be considered as a beneficial owner. Again, all of this is to say that they really want to find the information about every individual that owns the company or controls the company. There is a lot of gray area in this, and I know I will get likely a ton of questions, or people have a lot of questions about, whether this or that and what have you. I would love to chat with you about it offline, but you are not wrong in thinking that this is very gray. There is a lot of gray area here. Okay, so things to keep in mind. Substantial control. There may be individuals with substantial control over the business, even though they don't have any sort of equity in the business, just like we talked about. It could also be that someone exercises indirect control over an entity. So think about a trustee of a trust. They will be considered a beneficial owner. If someone has, I just talked about the marijuana example, we often have in the venture capital, sort of the private fund world, you'll have a lot of voting right agreements. Voting right agreements are also going to be considered as substantial control over the business. Okay. Okay, so how is ownership interest defined and calculated? Any questions in the room about anything I spoke so far? No? Okay, great. So how is ownership interest defined? Ownership interest, again, this is very broad. They want you to consider for that who owns 25% or more of the company. They want you to think about equity, stock, or any similar instrument. Capital or profits interest. Again, I shout out to all the real estate folks out here. If you think you have folks with profit interest only, they don't own 25% in the company, that is not true. Anyone with profit interest is also going to be considered a beneficial owner. Convertible instruments, anyone from the startup space who is out here, just because they're not on your cap table because they have a convertible note doesn't mean they will not be a beneficial owner. They absolutely will if they own 25% on a converted basis of your cap table. If you have individuals with put, call, any other options, think warrants, things like that, if they have 25% or more, they will be considered beneficial owners. And again, the lovely catch-all provision. If it doesn't satisfy in any of these items that they have called out on, then we have this big giant statement that says any other instrument, contract, arrangement, understanding, relationship, or other mechanism used to establish ownership. So it's a catch-all, okay? Again, operative thinking when you think about this requirement is, does somebody own 25% of my business? If yes, period, regardless of how they own it. Okay, now I want you all to think about what we initially saw, which is the ownership can be owned or controlled, and it can be direct or indirect. So what does that mean? Direct or indirect, or it can be owned or controlled. You could have actual ownership in the business. You could have individuals acting as a nominee, intermediary, custodian. Think about a great example of number 2 is if you have a minor who has ownership in a business, right? Like Motorola, for example, if they have a kiddo that owns a portion of their big business, someone is acting as the nominee intermediary. As party to a trust, so a trustee, settlor, all of the parties to a trust will be considered as owning or controlling. And again, catch-all. Any other contract arrangement, understanding, relationship, or otherwise. Okay, again, go back to, does someone own or control 25% of my business? If yes, the default should be I have to file the reporting requirements. Okay, so how do we calculate ownership interest? So oftentimes I get this question of, well, but it's 25%, but how do I calculate 25%? So the way you calculate 25% is at the present time. So easy way to think about it is if you are going into a transaction as of the date of closing, that's the present time that you are calculating, and any options or any similar interests that they have in the future, right? So again, if you have a deal where an investor gets, I'm totally making this up, but well, we recently did a transaction where we represented a client, sold their business for roughly $27 million. They got ownership interest in the acquisition or the acquiring entity, and some of which was to vest over a period of time. So if we need to calculate whether they own 25% of that acquisition or acquiring entity, we need to look at all of the ownership interests that they would have ultimately after the vesting period in order to see whether it qualifies as 25%. So say they got 10% on day one and they have the right to get another 15% over the next 5 years, we would calculate 25% on the date of closing, and they will be considered a beneficial owner of the entity. Profits, capital interest will absolutely be included, and the way you calculate that, this is going a little bit into the weeds, and I'm happy to share this presentation afterwards with you folks. But since we have everybody's attention, the way you would calculate it is percentage of the total outstanding capital and profit interest of the company. Percentage of the total outstanding capital and profit interest of the company. Okay? So it has to be 25% of the total profit interest in the company. Corporations, if you are a corporation, and I say corporation, but this is any entity that issues stock. Any entity that issues stock, the way 25% would be calculated is, do they control 25% of the total voting power, or do they own the value of total ownership interest at a 25% rate? Again, do they have 25% of the voting power, meaning do they control, for example, 25% of the board, even though they don't have 25% of the stock? Or two, they don't control the board at all, but they have 25% of the total ownership interest in the company. Can you see the difference? Okay, great. So are there any exemptions? Always, we have a general rule and then we have exemptions to who might not be a beneficial owner. There are very few exceptions though. And the exceptions are minor children, they're not going to be considered beneficial owners, but if they have a nominee, whoever their guardian is, that individual will be a BO, a beneficial owner. An employee of the company. So remember we talked about someone who has substantial control over the entity, would be a senior officer. Now, if the employee is acting solely as an employee, okay, and their economic benefits from the entity are solely because of their employment, then they're not going to be considered a beneficial owner. So an example of that is, say you have a VP of sales. A VP of sales is not someone who's considered a senior officer of the entity because they're not at the board level. They do have some control over their team, but they're not at the board level. They're not considered a senior officer. They will be an employee. We don't need to talk about them. There will be a lot of litigation, in my opinion, on this issue. There will be a lot of CEOs, CFOs who are going to fight on this piece, but we'll see what happens. An individual whose only interest is a future interest to the right of inheritance is also exempt. What I mean by that is, let's just pick on Motorola. If I was a child of, the Motorola family, I have a future interest in the business, I am not a beneficial owner today. Okay, that means I have no paperwork that says I'm going to get this ownership right now. Okay, a creditor of a reporting company is not a beneficial owner. So again, going back to my real estate folks, anyone who's out there, your lender is not going to be a beneficial owner, even if they have a lien on your property. Okay, who is a company applicant? This gives me a lot of heartburn because company applicants are individuals who are going to be filing all of these items for you lovely people. And they have not made it easy for folks like us, because we are also required to comply on your behalf, and if we don't, then we could also go to jail or pay $10,000 in fine. So when I try to tell all my clients and anyone who's out there, if you're my client, Please do not give me this heartburn. Let's work together to try to find these requirements ASAP. But okay, so who is a company applicant? Also, if I'm going too fast, please just raise your hand or drop a note in the Q&A and let me know. I have seen this stuff a million times, so I'm probably just skimming through a bunch. So please stop me. Company applicant. So who is a company applicant? They have to be one of two people. Anytime you see something highlighted, by the way, on the deck, it's because I want you all to pay attention to it. So any individual who directly files the document to create a reporting company. So what do I mean by that? Lawyers, paralegals, your general counsel, your company CEO, CFO, if they are filing the entity formation documents, they are considered a company applicant. What does that mean? If they are a company applicant, their information has to be disclosed. Okay? Okay, let that sink in. Okay. Or the individual who is primarily responsible for directing or controlling the filing of the reporting company. What does that mean? Someone who is the CEO, CFO is directing the attorney to file this for them. That person is also going to be considered a company applicant. Now, think of a Venn diagram, and more often than not, for small businesses, right, going back to who are they really trying to capture here? Small businesses. Small businesses will likely have the company applicant be a beneficial owner as well. Okay, so think of it, if you are a beneficial owner, if you feel like you are a company applicant as a small business, you will likely also be a beneficial owner, okay? Like I said, attorneys, paralegals, we will have to figure out how much they want to know about us and how much on the line our neck is going to be for information that is falsely provided to us and that we then go on and file. If you are a lawyer, CPA, anyone who's helping companies file this for them, please keep in mind that you have a certain period of time within which you can rectify any mistakes, but you will have liability as a company applicant for wrongful information. Entities that are created prior to January 1, 2024 do not need to include information on company applicants. What do I mean by that? So most of you people here must have, or I'm assuming here, must have entities as of today. You will have to file your initial report with the beneficial ownership information after January 1, 2024. What you don't need to do is include information about your lawyers at that time, or the people who have filed it, because I think FinCEN understands that, there might be entities that are way background from 1986. You might not have the individual alive today, God knows what happened, things like that. But after 2024, January 1, you will have to provide that information. Okay. Questions, comments, concerns in the Q&A. I'm going to take a quick look at the Q&A. And all of those with their hands up, please keep your hands up. Okay, please review exemptions from filing. Are trusts required to report? Great question. Trusts, the answer is, ready for it? Maybe. I hate it when folks give me that response, but the reason it's maybe is it depends on whether any documentation needs to be filed at the federal or state level for that trust to create it. So if you can create a trust without filing any documentation with any state government, state secretary, likely you are exempt from the reporting requirement. But if you have to file anything, then you absolutely will be considered a reporting company. Define beneficial owner. We went through, Cindy, all of this in great detail just now, but the short version is a beneficial owner, again, is someone who owns or controls 25% or more equity or voting or control over a business, or someone who exercises substantial control on the management of the business. That's the short version. Shashank, I have an LLC with my spouse and our annual real estate revenue is 30,000 annually. Do I need to file? I understand, yes, for this one as well. The answer is if you are in Arizona, if you are a US based LLC, you have less than 5 million, which is correct, and you have operations here in the US, you have less than 20 employees, if all of that is yes, then the answer is yes, you are a reporting entity, you do need to file. Okay, I have one LLC, Shashank, well done. I have one LLC with a partner, I'm gonna send you my bill right after. I have, just kidding. I have one LLC with a partner slash friend and our annual real estate revenue is under 20K, do I need to file? Yes, you do, assuming you have less than 20 employees, work here in Arizona, physical office in the US, yes. And you don't qualify in any of the other exemptions. Okay. All right.
Questions are coming in.
Okay, questions are coming in, but what I'm going to do is pause for now, keep moving, and then we'll come back. Victoria, hang tight. All right, great questions, you guys. I love it. I love it, love it. Okay, so once you filed your initial report, am I all done? Can I like chill out, go to Rocky Point, have a good time? The answer is no. You have to file updates. Once an initial report is filed, if anything changes on the information that you've submitted, I know, I feel your pain. I have a gentleman here who said, oh, can't believe it. But yes, you do have to file an update within 30 calendar days from the date of the change, not business days, calendar days, okay? Examples of what a change or what an update report would look like. Change in ownership. You suddenly have become an exempt entity because you went from being a for-profit to a non-profit. Happens all the time. You are an exempt entity. You have transfer of ownership from a minor who becomes now, an adult. Things like that. So think of it this way. Anytime you have filed information under the CTA and you think that information has changed because your address has changed or something like that has happened, you have 30 days to let FinCEN know of the updated information. Okay, 30 days from the date of change. And please think of your lawyer who can also get screwed if you don't do this, okay? Okay, so what are the penalties? So what are the penalties for non-compliance? Okay, so here's my overarching piece about this. I love what Congress is trying to do. They want to really go after bad actors. They really want to stop money laundering. But I do feel they're going after the small money launderers, not the big money launderers, right? Like the large companies are exempt, the banks are exempt, and all of that. But whatever that might be, I think that might change in the future. But in the meantime, they're really going hard on small businesses. If you fail to comply, for whatever reason, they don't care. For whatever reason you fail to comply, or you willfully provide false or fraudulent information, okay? There are civil fines of $500 a day, as long as the report is not updated. $500 a day for a small business is a lot of money. And you could also be subject to criminal penalties of a $10,000 fine or 2 years in jail. Now, what I don't know is how much budget FinCEN has and how much appetite they're going to have to actually come down on companies and implement it, right? Like they can have all the best ideas, but they might actually not have the budget to do anything. But I'm speculating, but I think they're going to try to heavily implement this regulation and really come down on folks. So please keep in mind that the penalties are very severe for not filing some paperwork. For companies that have senior leadership, keep in mind that your senior officer at the time of failure can have personal liability for this. And there are some safe harbors. So what I mean by safe harbors is if you know that you have failed to provide accurate information, you have, I think, 90 days to fix it. In some instances, I think if there's a change and it becomes inaccurate over time, so for example, going back to I'm a for-profit, I became a nonprofit, You have, I believe, 30 days to fix that. But if it's something like the beneficial owner, you have an investor, an angel investor, who has 25% in your business, their address changed, you had no idea. You found out much later. You have 90 days from the day you found out about that inaccuracy to update it. So 90 days, 30 days is sort of the timeline. Okay, so who can access this information? So I get a lot of questions about, okay, who is going to have access to this, right? Because confidentiality is important. What are they going to do with this information? Congress has said that this is going to be very safely stored in a secure database. Don't ask me what that means. Banner gets hacked. I mean, the VA gets hacked. I mean, it's possible that someone can get this information. But I guess the real important issue is, how are they going to use the information that they have, right? And the answer is that there are certain government entities that can request this information from FinCEN in order to use it for law enforcement. And so who are those law enforcement agencies that can use this information? So we have, of course, the federal law enforcement guys, national security, intelligence, the Treasury. The Treasury is interesting because I think they're also going to be sharing this information with the tax authorities, as and when the information is required. However, a lot of folks do actually report beneficial ownership on their tax return. So this is already information that they have. So we'll have to see how that will sort of play out. Any state, local, or tribal law enforcement agency, if authorized by a court order, can access this information from FinCEN. And any financial institutions can ask for it for customer due diligence if authorized by the entity. An example is, I want to set up, so shout out to all of the crypto, anyone in the crypto space. Say, for example, you want to start a bank account, or you're a Bahamian entity, you want to start a bank account in the United States. Chase can reach out to FinCEN and say, hey, we have this Bahamian entity, the entity in the Bahamas that wants to open this bank account. Can you allow it? Can you give us this information? They will then ask, FinCEN will ask the reporting company, or I believe the financial institution will get consent from the reporting company, and then this information will be shared. So there are some safeguards, as you can see, you need a court order, or the financial institutions need to get authority or consent, but largely it is for the feds to access this information. And again, big picture, right? They're trying to go after money laundering, so national security, terrorism, intelligence, that's what they're trying to get at. This information is not publicly available. It is not something that I can request under the Freedom of Information Act. Okay? So your neighbor cannot go and ask for this information about you. Okay. Okay, what steps must you take now? So all of this is great. You learned some very boring information. Hopefully not so boring, but what steps can you take now, or should you take now? So the reporting is going to be all electronic. Yay. We don't have to print stuff. We don't have to send stuff. I'm so glad to hear that. It'll all be submitted electronically, but they are still working on the electronic reporting system. Yeah, no surprises there, but government. They are working on the electronic reporting system. It is under development. Hopes is it'll launch January 1, 2024. Well, they have to, because if they want companies to file within 30 days, they need to have this in place. In the meantime, what can all of us in the room do? That is, for entities that have been created prior to January 1, 2024, you need to start identifying who your beneficial owners are. So when you are not able to sleep at night, or if you're like me, if you have a kiddo who stays up most of the night, sit down and try to figure out, okay, who are my beneficial owners? Who's my company applicant? How do I start putting this together so I can start preparing the paperwork? Because I can go back to the slide, but if you see, they need a lot of information from you, your address, your identification number, your photo ID, what have you. So start thinking about who these individuals are and start thinking about putting together the paperwork. You cannot file today. So for all the enthusiastic, the early risers, you won't be able to file this today, but you can start preparing and keep it ready so that you don't have to worry about the deadline. Any future changes to your beneficial owners or your company applicant also needs to be reported to FinCEN in the future. I think we already covered that, but just something to keep in mind. Disclaimer, this is more as a CY for me, but for all of you out there who are thinking, well, this is ridiculous, and like, I don't understand what substantial control is. If my mother owns some amount and she controls me, does that mean like, there are a lot of gray areas, and I'm here to help solve a lot of those because we understand how they're going to be thinking about beneficial control, what historically SEC has seen as beneficial control and things like that. So please don't stay up all night about that. Reach out to me. I'm happy to talk about it with you. Do not leave because I know Eric has some really, really important information to share about employee retention credits on the tax side. So please stick around for his information. But that's it, my folks, from my end. But before we end, I know we have a bunch of Q&A, so I'm going to try to answer any of that. My email is here on the screen. You are more than welcome to email me, reach out to me at the Rose Law Group. Again, I'm a partner and a director of the corporate transactions, so I'm happy to help answer any of those. Okay, so we'll go starting from Cindy. So if we close our companies by 1/1/24, I don't have to file this stuff. Make so little money, so much overhead. Cindy, please don't wait to 1/1/24. Close on December 31st, 23. And yes, you don't have to file it. Herman, do I have to file only for the LLC or also the family management company? Okay, so LLC, again, assuming all the other conditions are satisfied, you do have to file for that. I don't know what your family management company is. Can you share a little bit about that, perhaps in the chat, LLC, and things like that, then I can tell you whether or not it needs to be filed. Will the government be providing forms? Likely, yes. I own a single member LLC. Additionally, I have Herman, I own a single member LLC. Additionally, I have a family management company to pay my minor children. I would go with the answer is yes, because it sounds like it's less than 20 employees, less than 5 million in revenue. Yeah, let's go with yes, unless it's a trust or some other exempt. Look at the 23 exemptions that are available. Christine, do I need to include my lawyer who is a registered agent for my LLC created prior to January 1? If your lawyer is a company applicant, who is a company applicant? Someone who filed the registration for the LLC or someone who controlled the filing of the LLC, then yes, you do have to include them. Oh, if they're created prior to Jan 1 of 2024, then no. I'm sorry. So Christine, the answer to your question, assuming that Jan 1, 2024 is no. Victoria, we use an external company to assist us with our entity filings. We review the filings before they're submitted, but the other company handles the filing. Are they considered a company applicant? Likely yes. Ask them how they are dealing with all of the filing requirements because they need to have, again, I'm not going to go into the weeds of all of the stuff that we have to do as lawyers filing on behalf of our clients, but please make sure that they have their ducks in a row. Please review exemptions from filing. I think we answered those questions, right, from David?
I think so. I think we're all caught up.
All right, we're all caught up. Oh, Cindy has one last question. I have an LLC for rental property under my trust. I need to file for the LLC and the trust. Do I need to sign one for each trust? I have a supplemental care trust for a son and a family trust. Okay, lots to unpack there. You have an LLC for a rental property. Likely the answer to that is yes, you have to file for the LLC. Under your trust, I don't know if you need to file anything. It'll likely be exempt because you may not have filed anything to create the trust. But, and wait for it, it depends. So if you want, we can look at your trust documents and let you know if you need to file or not. But likely the answer is you don't have to file for your trust, but you have to file for your LLC. Okay, great questions, you guys. You weren't sleeping.
Nothing in the chat. Alright.
Yeah, I know. So, I mean, people in the room, questions, comments, concerns? Go
I would
ahead.
just like to say, we've all learned how much Ozark is that the people who are really laundering the money are not beneficial owners of any of these entities. So I really fail to see how it's gonna cut down on that, but it's just gonna give, the government additional information on every business activity.
Yeah, yes. Again, they're going after small businesses and they're going after entities that are, they're saying that they're saying, I have read this, that they're thinking that they can bring down $20 billion worth of money laundering down based on this.
You
So,
can say it.
sure.
And like all documents which are supposed to be private, they turn out not to be private. And the entities can just go into court, get warrants.
Yeah. Well, hopefully no one has to get a warrant against your entity, right? Like, let's start with that.
Disclosure.
No, I hear you.
Yeah.
I say that, I'm not trying to make light of it. It is very cumbersome for small businesses. But I think, keep in mind that if at any point of time, your entity becomes an exempt entity, like if it becomes inactive, if it's an LLC that's just sitting there without $1,000 worth of back and forth, close it. They're also trying to close a lot of businesses because what they're thinking is, and going back to your Ozark example, that's a great one. Ozark had multitudes of layers of entities that were intermediaries not doing anything. And so that's what they're trying to get at. They want to know all of the ownership information of those intermediaries all the way to the top. And so also if it becomes an inactive entity, they can shut it down or, things like that. Does that help? Not really?
No, I mean, it's to me, it's a disgrace, but, I'm old, so I lived in a different time for the most part.
Okay, yes, will you make your slideshow available? Yes. Thank you. If your American business laws is just so cumbersome and it's gonna hinder entrepreneurs, well, on the numbers they're trying to gather. Yeah. All right, Eric, take it away. I know you have some really interesting and amazing updates.
Well, I don't know how interesting or amazing it is, and but I'll do my best. So I'll start with, we really had not on the Flavor CTA side planned to share any information at all today. We felt it was enough to consume just on the Corporate Transparency Act. But in the last couple of weeks, a couple of things have popped up in regards to employer retention credit, and I thought it would be prudent just to share some information. So in the last 3 weeks, our firm has experienced a couple of clients who did not consult with us that responded to solicitations from third-party vendors. We would call them ERC mills, and advise us after the fact they had submitted employer retention credit applications and obtained refunds. A quick review of their eligibility from our perspective is that they were not eligible. And so just sort of fact. Last week, Jen, Mike, and I, the three partners of our firm, attended a 3-day continuing education seminar covering a variety of topics, but we got the opportunity to listen to 3 different speakers from the IRS. And although 2 of the 3 speakers were not intended to discuss the subject of ERC, all 3 spoke at length about employer retention credit. I think it's probably the most highly visible corporate event from a tax perspective that we've experienced in my professional career. The IRS believes that there is a massive amount of fraud involving this. And I think they're right. Based on what we've seen, the amount of solicitation we've seen in the marketing, these mills that are doing this aggressive marketing will be long out of business if you apply for and receive ERC and you're not eligible for it. The IRS told us that they intend to devote the greatest amount of audit resources they've ever devoted to a single subject in the history of the IRS. They've started auditing, and as they do more and more, they'll dial in their procedures with the intent of capturing more and more bad actors. It was pretty daunting, the amount of information that they're asking for. One thing that I want to point out to people is, if you do apply for it, what these companies are also not telling you is that you are required to amend the tax return for the entity that derived that benefit. So if Splaver and Splaver got an employee retention credit for 2020 and 2021, we are required to amend our corporate tax returns for both of those years and reduce our compensation expense by the amount of the credit. So by extension, if that's a pass-through entity, a partnership, or an S-corp, that also means the individual owners of that S-corp or partnership also are required to amend their tax returns. The IRS made it pretty clear that there's a massive deficiency in this area thus far, and of course they're able to track it because they know who they've issued refunds to and they know the type of entity that they are. So if you've received ERC proceeds, if you're not 100% certain that you're entitled, you need to check with your CPA if you're not our client. If you're our client, you need to check with us. We can review the requirements with you. Equally important, what they shared with us is that these mills are also not sharing their computations. And so when the audit arrives and the document request is delivered to the taxpayer, many of these companies aren't able to produce the computations for how the ERC was derived in the first place. In the absence of that, there will be 100% finding against your credit, and you will be assessed all the tax, plus all the penalties, including reckless disregard penalties, which amount to 25% of the tax in question, plus interest. Just for the record, interest on 10-1 is going to go up to 8%. We're at 7 now for underpayments. The IRS announced yesterday they're raising to 8. So, you're going to have to give your money back. You already paid your provider anywhere between 10 and 30%, depending how aggressive they were on their fees. You're likely never going to get that money back, and you're going to pay a 25% penalty plus interest. In Arizona, so get those calculations if you had it done. In Arizona, you can generally qualify one of two ways: either a reduction of revenue in 2020 or 21 relative to the comparable quarter in 19, or as a result of a government shutdown order or an interruption of supply. The revenue calculation is simple and straightforward, but what these companies are relying on is a very broad interpretation of a government shutdown order. IRS rules are pretty clear here. There must be a very specific order that triggered your entity shutdown. Social distancing orders do not qualify. If you're domiciled in Arizona, and frankly, in any state where you had a predominantly Republican legislature and governor, likely you don't have a lot of government shutdown orders, because in our state, we didn't get many. And even when they did issue them, many businesses were exempted in the very order itself. As it relates to supply chain interruption, again, another area where they're trying to rely, the vendor upon whom you relied must be subject to a government shutdown order in their jurisdiction, and you need to be able to produce it and demonstrate that they were shut down. As well, you must have no alternative source of supply. So it may very well be, if you're a doctor and you're relying on an artificial hip, and your manufacturer got shut down, if you can't get that hip anywhere else, you're okay. But if there's an alternative source of supply, you're not. So I would look at all of these marketing campaigns with a very jaundiced eye, and if you think you qualified, I would revisit it. If you conclude you filed an error, you need to go back and refile your 941s, your payroll tax filings for the periods in question. You need to send the money back. If you send the money back before you get audited, they will not penalize you under the responsible party rules. They will likely charge you interest, but you will avoid the substantial penalties that exist. And the greatest risk here, and then I'm done, is when Congress passed the CARES Act and introduced the employment retention credit, they gave the IRS an additional 2 years to audit. So there's a 3-year statute of limitation normally for audit on filings, corporate tax returns, payroll tax returns, et cetera. For auditing of ERC claims, the IRS has 5 years. Your very worst case scenario is you filed for 2020, you paid your vendor, you amended your tax returns, you paid tax again on the ERC proceeds you received, and in year 4, after the statute of limitations has lapsed on your corporate tax return, you get audited, the IRS assesses, and you have to return those dollars. The statute has now closed your ability to go back and re-amend that 2020 return, and so you will have paid tax on proceeds that you've paid back, and of course you will have paid massive penalties and interest on top of it. So please, if you're out there and you're one of our clients and you filed and you haven't told us yet, reach out to us and let us take a look at what you've done. If you're not one of our clients and you're not comfortable asking your CPA, you're welcome to contact us as well. We're happy to take a look. But rest assured, if you receive a substantial sum, you are going to get audited. I mean, they basically told us anything over $500,000 is going to get an audit. So I'm off my soapbox. I'm done with ERC. I hope I never have to talk it ever again. Thanks everyone for being here. Shruti?
Thank you, Eric. That is, wow, that's crazy. Anything over 500,000, okay, I feel like that's a lot of folks. So yes, Eric is amazing. If you are one of our clients of the Rose Law Group, I highly recommend reaching out to Eric and their group for their CPA services. I think 100% recommend anybody that I work with to Eric. He is phenomenal. So with that, again, thank you so much everybody for your time. We talked about the Corporate Transparency Act. Again, quick reminder, January 1,
Thank you, Shruti.
is the day. So thank you again, everybody. Have a wonderful time and stay safe.